Welcome to Ground Rules, employment law over your coffee break. My name's Pam Howland, and I'm here today with Doug Plass and Jennifer Walrath. And we're talking about a recent, in the big scheme of things, recent Supreme Court case called Muldrow versus City of St. Louis. And this case kind of landed on our radar because of a panel that I was on back in September for the SHRM Employment Law Conference. So for those of you who attended, this might sound a little bit familiar because the lunch panel talked at length for about an hour on implications of this United States Supreme Court case. The implications from it are pretty far-reaching and really interesting. So we wanted to make sure that if you didn't have the opportunity to attend that conference, that you get the same info and you have it in your toolkit to consider when you're thinking through what the current legal climate is when it comes to claims of discrimination. So let's talk a little bit about the facts of that case and really like what that case was about. And then we'll talk a little bit about what the United States Supreme Court decided in regard to it. So Doug, Jennifer, anybody want to kind of kick us off with the facts, or I can too? I think the facts are interesting.
This case involved a police officer with the city of St. Louis, and she was transferred from a plainclothes position where she had a lot of interaction with commanders and kind of higher level folks and kind of a more prestigious position into a uniform position where she was still she was in a supervisory capacity. It was a lateral transfer in terms of her rank and her pay and everything else, but she did lose a take-home car and maybe something else. In this case is just about whether or not that transfer itself qualifies as a adverse employment action under Title VII.
Yeah, I was looking at an article this morning that had a few more facts on it, and the factual context is interesting, I think. So in addition to what Doug said, it indicated that this woman had, by all accounts, what looked like a really fun and satisfying law enforcement job. She was investigating human trafficking. She oversaw the gang unit. She was the head of gun crimes. She was deputized with the FBI. So it looked like a really prestigious, probably if you're in law enforcement, that seems like it would be a really cool job. And then for some reason, she gets transferred to back to a uniformed position with primarily administrative tasks. And in her place goes a male employee. So she's replaced by a man, brings a claim under Title VII for gender discrimination. And like Doug said, this case goes all the way up to the United States Supreme Court with the question of, did she show that she was damaged enough to establish a claim under Title VII? And that created a decision where they really talk about what is the standard under Title VII for bringing a claim.
And what I was going to throw in there is I think what was important in this case too is that her transfer, there wasn't some reduction of pay or like benefits, right? So there weren't what we would think of as the classic direct impact to, terms and conditions of employment. Like she was still being paid, I think at least the same. And there hadn't been any material impact to like those parts of her job.
Yeah. No, that's my understanding too. So, typically, as long as, I've been doing this type of work, we think of an adverse action as being demotion, termination, failure to give someone maybe like a position, a promotion they apply for, something like that. And this really goes to, does a plaintiff need to establish something like that in order to state a claim, or is it enough if you have a change to your duties and a general sense that I went from a job I really liked to a job that was much less satisfying to me? And the United States Supreme Court jumped in, tackled that issue, and at the end of the day, they concluded that the standard is a plaintiff must show some harm in order to state a claim of Title VII. And that contrasts that with what some courts had previously held, which is there must be a showing of significant harm. So it's this question of some harm versus significant harm. And we now have this U.S. Supreme Court case from 2024 saying some harm is enough. So where does that leave us? What does that mean? What's really interesting is if you look at some of the legal commentators talking about this case, even, analyzing what the Supreme Court justices had to say on it, there was, at least one Supreme Court justice saying, some harm. I don't even really know what that looks like. And I think I echo that sentiment, right? Like, what does that mean to show some harm? That seems like a very vague and amorphous standard. So what we know is that was in 2024. And the question now becomes, like, what are courts doing with that? And what are plaintiffs' attorneys and what is happening to cases that were already in the system in light of that United States Supreme Court decision? And that's where it gets even more interesting and where we wanted to share that with you. Because what's funny is in that U.S. Supreme Court case, some of the justices were saying, this doesn't really change anything. It's not that big a deal. And what we know now is that that's not really true. It probably is a big deal because since that case across the country, many appellate courts and district courts on the federal level have grappled with that Muldrow decision and have applied it in a variety of contexts. So we're in Idaho. I can't say there's been any Idaho cases examining it yet. Certainly doesn't mean there won't be, but we have seen cases from other courts around the country. And we want to talk a little bit about what's going on with those cases. So Jen, Doug, are you guys seeing anything that seems noteworthy on this front in regard to courts following the Muldrow holding?
I'm probably going to forget some of the niceties of the facts, but one of the ones that really stuck out to me, and I think this was in the Eighth Circuit, which... again, this is kind of from some of the commentary that has come out since the Muldrow case, but apparently the Eighth Circuit, which is kind of in the Midwest of the United States, was one of the kind of strictest districts or circuits in terms of applying this like significant harm standard, right? So making it so that if you're a plaintiff, you really have to show an adverse action that harmed you, right, in order to pursue your claim. And I guess there was a case there that had been decided on that standard in the lower court, and it was up on appeal with the Eighth Circuit. And they, in the middle, the Muldrow case was decided, right? So now the Eighth Circuit is looking at this decision, but applying a some harm standard instead. And I believe the facts of that case were something along the lines of an employee saying, my supervisors scream at me. I'm kind of getting given all of the crummy work to do in my team, in my department. And I'm also kind of being forced to work more than other people, right? So certainly things that sound unpleasant, but perhaps don't rise to the level of something like, cutting your pay or demoting you or terminating you, right? And the appellate court looked at that and they said, they didn't say that it definitely met the standard of some harm, but they said it could and sent it back down for the district court to look at it. So I think that's just very interesting, right? I know we have some other, equally interesting ones to talk about, But I think that one is especially informative in terms of how much this, like that case may otherwise have gone away for the employer, right? If that employee couldn't show that what she claimed happened that harmed her was sufficiently adverse under the standard of Title VII in order to say, you know, you discriminated against me based on my protected class status. Now that case is still, well, I guess I can't say for sure that it's still going. Perhaps it's settled since then. But, you know, certainly the court kept it alive under the new standard.
I was also looking at a case out of the Eighth Circuit this morning, and so the Eighth Circuit's very busy right now, apparently. And in that case, it was an employee that had some vision issues and was placed on permanent work restrictions, which actually disqualified him for his position. And he submitted a new doctor's note to the fitness for duty examiner, clearing him to work, and the fitness for duty physician sent a letter saying he would not consider any additional information because the restrictions were permanent. And what the Eighth Circuit said in that case, applying Muldrow, was this denial of a further review of a medical condition. That in itself was an adverse employment action, which kind of blows our minds here a little bit. So, yeah, I guess you try to get your head around that. Jennifer's looking at me funny across the table.
For an accommodation.
Yeah.
Okay. Yeah. Can you tell I haven't read this case yet? This really is sitting here. My mind is like...
That's the Palmer case.
Yeah, that is one of the interesting things about Muldrow is that courts are applying it not just to Title VII, but to the ADA and to the ADEA, which for those of you who might not remember, that one's the Age Discrimination and Employment Act. So it is being applied in other contexts other than just claims of, you know, Title VII discrimination, which would be, you know, gender, race, religion, national origin, those type of things. So that's super interesting that it is being extended to these other federal statutes. And I've ran across a few cases that had, just like the ones that Doug and Jennifer mentioned, you know, interesting sets of facts. So one involved an employee who had been reclassified from exempt to non-exempt. For those of you out there who, like Doug, love wage and hour law, they know that this is probably, like, employers don't love to reclassify people. That probably came after a lot of time and consideration. But the court in that case said, yeah, reclassifying someone from exempt to non-exempt, maybe that could be an adverse action enough to state a claim. So that seems significant and alarming. And then we've also seen cases with things like the one, maybe this is the same one that Doug ran across, but I saw one where a court was examining whether an employee had suffered an adverse action when his supervisor was reprimanding him for parking in the wrong spot, using the wrong facilities, and the employee felt like generally he just wasn't being treated fairly. The court in that case said pointing out errors, probably not enough. So yay for employers. There's one win on the employer side where maybe that's not some harm. But it sure seems like a lot of the other cases are going in a different direction, finding, yeah, I mean, it really can be almost anything to show harm at a level significant to state a claim.
And along the same lines, I was looking at a case out of the Seventh Circuit, and this involves something that happened in 2014, right? So 11 years ago now, and just last month, the Seventh Circuit said, in that case, said that placing an employee on a performance improvement plan, you know, with this particular set of facts, was not an adverse action because it didn't change the terms and conditions of employment. But in other cases, a performance improvement plan maybe is an adverse action. So it's really going to be dependent on the particular facts that these different situations have.
Yeah, that question of whether putting someone on a performance improvement plan is significant to create an adverse action or some harm under Title VII. That one came up at the SHRM panel when we were at the conference in September. And for those of you who were there, you might recall that panel, I think it's worth talking about because it was just, for me, super interesting and fun and informative. But that panel had an attorney who's a plaintiff side counsel who sometimes does, I guess I don't know this for sure, but I'm speculating, like contingency type work. And the moderator asked him, do you think that it is some harm significant for an employee to state a claim under Title VII when an employee is put on a performance improvement plan? And his answer was yes, for sure.
And there's a case out there that says the same thing since Muldrow. Now, I think in that instance, there may have been some question marks about, was there actually a good reason for the performance improvement plan? But the court was looking at it as it's a kind of permanent black mark in this person's personnel file. And so it does have kind of long-term consequences for this employee down the line. If people are looking at her for things like promotion or, pay raises, and they go and look in the personnel file, right, and see there's a PIP in there, PIP, performance improvement plan, what does that do for that employee's stature and status and ability to advance? And then there were some other things in that case as well. It wasn't just a PIP standing alone. But I think for a lot of us, and probably a lot of the listeners, that is kind of mind-bending, right? Like a PIP has always seemed like a safe and appropriate thing to do for managing your employees and their performance. And now we're sitting here in a world where down the line, if something else happens, perhaps that ends up being evidence used against you in a lawsuit.
Yeah. I guess I would want to add here, because I'm a big believer in documentation and performance improvement plans being really my favorite type of go-to documentation. So I do want to be clear. I mean, if a performance improvement plan issued in good faith when the facts justify it, for a manager to coach an employee on how to improve and to give them notice of deficiencies and things that aren't working. Would I still recommend that even after Muldrow? Absolutely. I mean, I still maintain that a PIP by far outweighs any risk you're going to have under Muldrow. I still think that there are more checks in the yes, you should do this column than in the no, it's risky column. But it is really super interesting and something that, we should watch for as the cases develop on this.
I mean, that's kind of where I've landed on a lot of this is it's not that employers should now be terrified to do PIPs or terrified to demote someone if it's appropriate or, to do verbal discipline or written discipline. But I do think it highlights the need to take those things seriously and think through them like you would anything else, right? I mean, they're everyone's human. I think sometimes it is maybe easier to think, oh, it's a lesser form of discipline. Maybe we just don't have to think about it as much. I think this case just encourages you to take all forms of discipline seriously. Make sure you have a legitimate reason for them. And if you do and it's documented, then, you may still face a lawsuit down the road, but you've got your house in order. You have good documentation to defend the case. And I think I speak for everyone sitting here that we will always be happier to have a case but there's a legitimate reason the employer can show for whatever they did, that this employee is now, alleging violated the law. That's always going to be a better case because, the employer can show that they acted for lawful reasons and what they did was not in violation of the law.
Yeah. I'd add, too, that on that panel that we had back in September for the SHRM conference, there was also an Idaho Supreme Court justice on that panel. And she talked about the importance of documentation And for any employer out there who's wondering, do the benefits of documentation outweigh the negatives? I mean, you can take it from her, because her message to the audience during that panel was, look, if you have a case that comes up on appeal and it lands in front of us, we're looking for documentation. If an employer who has their decision supported by documentation created contemporaneously at the time the problem's arising, pretty hard to argue with that. So, take it from people who, you don't have to take it from the lawyers who represent employers. You can take it from the judges deciding these issues. She said, make no mistake, documentation is your best defense here if you have a claim brought against you. And that's pretty persuasive to me.
Yeah, and I was just thinking about this whole performance improvement plan issue as to whether it's an adverse employment action. And I think this is kind of something where we can highlight the need for good policies as well, because a lot of times we see the situation where, and I think these are the types of performance improvement plans that could be adverse employment actions, where it's like, we don't have a whole bunch of policies, but the employee is kind of doing stuff we don't like. So we're going to, write all that out and put them on this plan. And then the employee can say, well, this is all new to me. You didn't have this all written out in policy. So this actually is a change in the terms and conditions of my employment, versus a situation where everything's in policy. The performance improvement plan is put in place to reinforce your policies and make sure that they are followed. So that's, that might be the distinction that courts are kind of finding here.
Yeah, and I'll throw in also like job descriptions, right? Because to the extent that it's performance-based and maybe not conduct-based, which tends to be what policies are more concerned about, kind of having a good job description, or at least somehow having communicated to the employee what the expectations are of their role is very helpful. And then being able to say, and now you're not meeting them in these ways, and that's why we're doing the performance improvement plan.
Yeah. So I mean, I would say in closing, take it from Doug. You should always make sure you've got good policies. And if you haven't done that in 2025, now's the time to do it. Or, we're almost headed into 2026 here. So you should be doing it every year anyway. Like Jen said, job descriptions updated, your supervisors knowing like the value of the job description and how they can, rely on that and refer to it in coaching conversations, maybe, not to mention in all the other scenarios where job descriptions are helpful, like under the ADA or wage and hour issues. And then I guess, just bigger picture even yet is knowing we're in this climate where we now have a standard that makes it easier for employees to bring claims. And I would say on that panel, we had a representative from the Idaho Human Rights Commission and then from the EEOC. And both of them said that 2025 is a year of increased claims. I can't remember the statistics, but I know that here in Idaho locally, the increased number of claims was significant. The EEOC, they reflected the same thing. They have more claims in 2025. Obviously, a lot going on with that agency and with changing and shifting priorities. But increased claims on a state level, on a federal level, law that makes it easier to bring claims. I think the biggest takeaway, do your supervisors understand the law? Do they understand what they can do, what they can't do, why they should document, what the purpose would be, how to do it, when to do it? If not, get some training and make sure, as you've heard from us, the law has changed and shifted in 2025. Make sure that you're following along with that, and that your supervisors are following along as well so they understand their duties under that law. So that's it for today on Ground Rules. We hope you got something out of that and enjoyed the Supreme Court legal update there. We have a webinar coming up on November 14th. I wanted to tell you about. It's called Compliance Consideration in Times of Political Chaos. That might be something to check out. And then I'm pretty sure we're going to have a year-end update here too on December 10th. Yes. So all those things are things to look forward to. And as we head into 2026, we'll get our new training schedule out there as well. So that's it for today. We'll see you next time on Ground Rules.
Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.